rise. Court of Appeals Division 1 is now in session.
Oh, please be seated. Almost took a fall there coming in. Good morning, counsel. Let me call the case. This is case CV15 420, Noreen Passmore et al. Versus James Mccarver et al. This is the time set for oral argument. Counsel, you both have 20 minutes to make your argument. Is it Mr. Berlin?
Yes, sir.
You can set aside some time for rebuttal. Just let us know. You can keep track of the time on the clock on the podium. We've read the briefs. We're very familiar with the cases. We understand the issues. I would just caution you or let you know that these proceedings are being recorded and they will be uploaded to our website. They'll be available for anybody in the public to watch. With that being said, Mr. Berlin, your argument.
First, if I may, Your Honor, I mean no disrespect to the court showing up in sneakers. I had surgery on my foot a couple months ago. And
That's okay.
somewhat limited.
What kind of sneakers?
I'm sorry?
What kind of sneakers?
My wife made me get Skechers, Jeff.
I can't have anyone with Skechers in here. That is too Sun City for me.
I blame my wife.
No, okay. No, that's fine.
I'd like to reserve 5 minutes if possible, Your Honor.
Right.
My name is Larry Berlin. I'm a solo practitioner in Tucson, and I represent Noreen Passmore. Ms. Passmore suffers from a severe, disabling, disfiguring, and painful movement disorder called tardive dyskinesia. She suffers from TD as a result of the alleged negligence in this case by defendant Dr. Mccarver and defendant nurse Lorenz. Dr. Mccarver, if I understood correctly, is board certified in pediatrics, has an interest in practices with an interest in emergency medicine, initially wrote the first prescription that's involved here on an emergency basis or in an emergency room setting, and practices family medicine. And I have been, it was an early question in the case, what specialty would be required for an affidavit with respect to...
Has your client ever identified that?
Yes, we eventually did with prior counsel for Dr. Mccarver, who indicated that he thought family practice was appropriate. And the affidavit that was eventually filed in the second case, the case filed under the saving statute, is from an expert in family practice. The prescriptions took place over the course of 5 years. They were for an antipsychotic that is in a class of drugs, and this specific drug were known to cause TD. The negligence that's alleged is in the initial prescribing at all. The prescribing for a total of 5 years consecutively, and for the failure to monitor for TD. If TD is monitored and caught early, it will go into remission and go away. Turning to the issues before the court, the point of the saving statute is to save cases that were timely filed but were dismissed after the statute of limitations by means other than abatement, voluntary dismissal ordered by the court, a decision on the merits, or lack of prosecution. Lack of prosecution or the late or later finding of lack of prosecution is what brings us here today. In the initial lawsuit, actually even before I get there, the statute requiring the preliminary affidavits, 122603, and its subsection F, that in this circumstance requires dismissal or required dismissal without prejudice, also serves the same purpose as the saving statute. Both of them are are for the purpose of seeing to it that cases are resolved on the merits. Here in Arizona, I'm sure I don't have to instruct this court. We have a strong preference for resolution of cases on the merits. Also, resolution on the statute of limitations is disfavored. And what we have here is the saving statute was required because the dismissal was after the running of the statute of limitations. And the second case, the one that was filed under the saving statute, was dismissed ultimately because of the statute of limitations running.
Well, but it wasn't just because the statute of limitations ran, right? I mean, 122603 has deadlines that are mandatory, but these even were extended in this case.
Yes, sir.
The extension wasn't complied with, and even at the time of the hearing on the motion to dismiss, there still wasn't compliance. There wasn't even proffered compliance. So how do you argue that there was no opportunity to resolve the case on the merits?
Your Honor, in the first case, in the initial case, there was an opportunity to resolve the case on the merits.
And can you say that case was diligently prosecuted?
Yes, sir. With the exception of the affidavits, it was. Disclosure statements were exchanged. 26.2 exchanges were made. All parties exchanged interrogatories and answered them. In some situations, there were both uniform and non-uniform interrogatories. I believe there were requests for production to which there was a response.
But the statute isn't just an ancillary requirement sort of bolted on to the normal litigation process under the rules. It's a prerequisite to resolution of the case by command of the legislature. Don't we have to look at that as an element of prosecution?
Yes, sir. And in the same vein, the legislature enacted 2603F, again, for the purpose of circumstances where the affidavits are chronically insufficient or not filed, so that there would be an opportunity to resolve on the merits. And perhaps even more to the point here, Your Honor, if I may read just for a moment from Sanchez versus Old Pueblo Anesthetics. And by the way, I need to make a quick note and apology to the court. Sanchez is quoted and cited in plaintiff's opening brief, and I noticed in preparing for this morning that it's not on the case list at the beginning of the brief. So I apologize for that inadvertent omission. At paragraph 20, Sanchez points out that 122603 erects an orderly procedure by which the respective parties can litigate what expert witness testimony will be necessary and what experts must therefore be disclosed, and it does not contemplate dismissal with prejudice as a sanction for deficient preliminary affidavit. The cases, I can't recall offhand whether it was Sanchez or Short versus DeWalt, Your Honor, which is also cited and quoted in our briefs.
Mr. Berlin,
Yes.
let me ask you a question.
Yes.
You say that the case was prosecuted with the exception of this affidavit. Standard of care expert is the case in a medical negligence case. I mean, that's the biggest piece of evidence, unless you've got some type of sponge that's left or something, some patent medical negligence issue. If you don't disclose who your standard of care expert is, and as I understand it here, this thing lingered on for 19 months after you filed the case, your client filed the case, you still hadn't submitted a preliminary affidavit for a standard of care expert. And that's just, when you say the case was prosecuted, I don't see how that can be. I mean, that's kind of like asking Mrs. Lincoln, other than that, how did you like the play? It's
yes,
a pretty big piece of...
And in accordance with 122603, which requires the affidavits and also under these circumstances requires the dismissal without prejudice. The case was properly dismissed the first time around. The issue is whether Ms. Passmore had a right to refile under the first automatic provision of the savings statute, and she did. The order...
But so your primary argument is that this fell under the as of right filing,
Oh,
refiling.
absolutely, Your Honor.
So then you must be saying, by definition, that noncompliance with 2603, even for a period of years, does not constitute failure to prosecute.
Yes, sir. And the ruling that dismissed the original case was based on 122603. It was not based on lack of prosecution. Lack of prosecution was not fully briefed in that motion or argued. The defense submitted a proposed form of judgment after the judge ruled dismissing, indicating that he was the proposed form of judgment indicated that the dismissal was with prejudice and for lack of prosecution. The judge specified in rejecting that he was rejecting that it was outside the scope of his ruling, and then specified that his ruling was under 122603F. It is only later in the second case, after that was a final determination, that Judge Mackey made another determination in that case.
I understand that's the procedural history, but let's talk about the law. If a party fails to comply with Rule 26.1 for a period of 19 months, could that be failure to prosecute?
It depends on the circumstances, Your Honor, and there are cases in Arizona with varying time periods for varying failures to go forward in aspects of the case that will rule differently on that. And I think, although that could be a close call, that is a close call that was not litigated in the first case and that was rejected in the judge's order.
Okay. So what would be then, in your view, a good example of conduct that constitutes failure to prosecute?
In this case or generically, Your Honor?
Well, generically. I mean, we're trying to define these terms legally so that we can apply them consistently to all people. So what in your mind is the core failure to prosecute? Respectfully,
Your Honor, I don't think that matters in this case. That is not why the case was dismissed and initially in the first round, and that is not what the final determination said. And the plaintiff has a right to rely on...
Sir?
Yes, sir.
You're not answering the question. You keep coming back to the procedural history of this case. I'm asking you about the law. So telling me that the question isn't relevant doesn't help move the argument forward.
Sorry, sir. Failing to, here in this medical malpractice context, failing to exchange medical records, failing to provide releases for the defense, all of the releases they wanted for medical and other records, failing to make disclosure statements.
Okay. Failure to make disclosure statements. Here you say disclosure statements were made.
Yes,
but
sir.
Those disclosure statements did not include, as far as I'm aware, the disclosures of expert testimony, which is the core evidence in the case.
Let me dovetail off of that question.
Yes, sir.
What if there were no 122603 and your client just simply never produced a standard of care expert? Would that be a failure to prosecute?
It might be, Your Honor. In this case, that was not litigated. And the suggestion of that after the issue was litigated was rejected.
With that concession, isn't the failure to produce the preliminary expert affidavit tantamount to a failure to prosecute?
It could be, Your Honor, yes. However, If the case had been dismissed, the original case had been dismissed for failure to prosecute, for lack of prosecution, again, a point that was specifically rejected by the trial court, then plaintiff would have had an opportunity, would have had certain rights that would have attached at that point. Plaintiff could have appealed that ruling. We could have brought the very question that the court is asking me now to this court at that time in the context of a dismissal for lack of prosecution. Those rights did not attach for Ms. Passmore because the ruling didn't go there. Then in the second case, which Jepson, Sanchez, DeWald all refer to as an entirely new claim, in the second case, the judge made an additional finding about the first case after the final determination, and that additional finding changed the plaintiff's rights, changed her substantive rights, and took away what, on the very face of it,
In the first case, did the judge say that the case was not being dismissed for lack of prosecution, or did the judge simply decline to opine on that issue, preferring instead to rely on the narrow basis for dismissal, which was the statute?
His precise language, Your Honor, it was a brief sentence in the ruling of dismissal, was that he was not adopting the proposed judgment because it was, or I don't remember what that language was in the sentence. The key language was because it was outside the scope of his ruling. Exactly.
So he was not being asked at that point, and could not have been asked at that point, to pass on the question of the applicability of saving statute rights. He was only being asked to dismiss the case under a statute. And so it seems to me that the trial judge was being appropriately narrow in his ruling, but not precluding further consideration of what that ruling meant.
It's an interesting point, Your Honor. Preclusion attaches once that ruling becomes final. Once the judge's ruling that in effect, lack of prosecution is outside the scope of what I've decided, and the defense did not appeal it, did not move for reconsideration, nothing, let it stand. It became a final determination. And so going back and saying, gee, I didn't rule on it first time around, but now we're in a second case after the first one had a final determination, and I'm going to add another determination now about that case that changes plaintiff's rights. Can't do that, Your Honor. That's where the preclusion happens. At the point at which the first dismissal becomes a final determination, then the judge is precluded from making further rulings in that case. Respectfully, sir, you have a quizzical look on your face.
I hope I'm because if the issue isn't before the judge in the first case, because obviously there can be no motion to dismiss for statute of limitations, the first case was timely filed, right?
Yes.
So if the issue isn't before the judge in the first case, and the issue can't be raised in the second case.
I see where we're missing each other, Your Honor. The issue certainly could have been brought to the judge in the first case. Not the 504 issue, although, yes, that could have been and sometimes is brought to judges under these circumstances. But the issue of lack of prosecution was available in the first case. As you all have been pointing out, there is a question here as to whether failing to provide those affidavits could have been considered lack of prosecution, or whether that is essentially excluded by the language and the structure of 2603. But the lack of prosecution, if that's what it was, occurred in the first case. And although it was not briefed or part of the motion that got it dismissed, that is specifically what the judge said was outside the scope of his ruling. He certainly could have dismissed the case for lack of prosecution. The defense could have focused on that much more specifically and clearly in their briefs, and the judge at the time that they presented the proposed order. Could have said, yeah, this is a lack of prosecution, and signed off on that. He did not. He rejected that, and that rejection became a final determination, which precluded him going back and changing it for the second case. I see I only have a minute and a half left. I would like an opportunity to address the Jepson factors, if indeed they're brought up by the defense, and so I'll reserve what little time I have.
Okay, thank you, Mr. Berlin.
Unless there are other questions you want me to address now. No.
No, not
Thank
at this
you.
time. Thank you. Mr. Meyer?
Yes, sir.
Your argument.
Thank you, Your Honor. I apologize for my footwear as well. This is a Darko wedge that I'm wearing because of my surgery.
What is it?
I have a shoe that's, I had surgery on my foot as well, so
Okay.
apologize for that, not having a dress shoe here. I'm going to try to split my time evenly with my co-appellee. So, please the court, my name is Kevin Meyer from the firm of Broning Oberg. We represent Nurse Lorenz in this matter. There's no magic language that's required in a dismissal in order for that dismissal to be indicated as, or for that dismissal to be, as a matter of substance, a dismissal for lack of prosecution.
Is it, in this case, would you say it's as a matter of substance or as a matter of law?
I would say as a matter of law, Your Honor.
So would you say that the law is that every time a case is dismissed for failure to comply with 2603, that is, as a matter of law, dismissal for failure to prosecute?
I think you can make that statement. Yes, I think that is an accurate statement of the law. Especially in this case when you have 19 months of delays for producing what everyone has indicated is clearly the preliminary affidavit, which is a prerequisite to the suit commencing in the first place.
Just so I understand the argument then, you're saying that there's really no other way to characterize a dismissal for failure to file that affidavit under 122603. It is, by failing to file it, a dismissal under subsection F. It is a dismissal for failure to prosecute.
Yeah,
It's not a trick question.
Yeah,
I'm
no,
just
I'm
asking.
sure. Yes, it is essential to the very nature of the claim. It is essentially an element of the claim, and the claim cannot proceed and really cannot begin at all until that preliminary affidavit is filed.
So when Judge Mackey has the case come back, it's refiled, and he's looking at the savings statute argument, is there any other way for him to view the dismissal, the prior dismissal, than a dismissal for lack of prosecution? Is there any other way to characterize that?
No, I mean,
how can you conceive of a way where that dismissal under 122603F could be a dismissal for anything other than a failure to prosecute? I'm asking you.
yes, I don't believe so, because the preliminary affidavit is required and is supposed to be filed either contemporaneously with the complaint or with the initial disclosure statement, which is supposed to come 40 days after the answer. Theoretically, you have 2 years as a plaintiff before the statute of limitations runs to obtain your affidavit, so that when the statute of limitations is approaching, you're ready to file and your affidavit is already in place. I mean, as some of the judges here have said, it's the central aspect of the case.
So when Judge Mackey has his case refiled a couple years later and he looks at it and he says, I look at the dismissal now and it was for a failure to prosecute, was there any other way for him to view that prior dismissal other than as a failure to prosecute?
I think as a matter of law, no, and also certainly specifically on the facts of this case, given what Judge Mackey knew as the prior trial judge, based on what his memory of the case was, I don't see how he could have concluded otherwise.
So to reduce your argument down, then, the rule you would like to see articulated is that no one who experiences a dismissal under 2603 is ever entitled to automatic relief under 12504.
Certainly not when multiple chances to produce the affidavit have been given by the Superior Court prior to the dismissal pursuant to
Well, if you
2603.
if you lift the tent up that much, is it really then as a matter of law?
I think, without question in this case, the facts support that this case was a dismissal for lack of prosecution under any definition of lack of prosecution.
What else could it be? It's not a sanction. It's a statutory requirement, right?
Yes.
So the judge didn't sanction the plaintiff in this case. I'm just trying to conceive of what else it could be.
No, it's a fundamental missing piece of the claim. It's a portion of the claim that hasn't been proven and that is necessary to even begin the suit in the first place. And because that is not present, either through lack of diligence or through an inability to find an expert willing to testify to that effect, the claim cannot proceed, and there is no basis to go forward. Allow me to see if I can clarify a little bit about the procedural aspect of this case. The appellants have claimed that the judge explicitly rejected the basis of lack of prosecution as a reason for dismissal. But I think if you look at pages 18, 19, and 20 of the opening brief appendix, you'll see what happened is that there was a proposed form of judgment that was submitted that on page 20 asked for the dismissal in the first suit to be dismissed with prejudice. And that's really what the judge was rejecting. The judge was stating that he was only dismissing pursuant to 2603F, which under the plain language of the statute does not permit dismissal with prejudice. It only permits dismissal without prejudice. So that's really what was being rejected by the trial court in this case, not some greater argument about whether that constituted a lack of prosecution under the general definition or under 41B. So I think it's wrong to say that the court explicitly rejected the notion that there was a lack of prosecution in this case, because what the court was really rejecting was the idea that this dismissal, the dismissal of the first suit, could possibly be a dismissal with prejudice on that basis. As previously stated, the Superior Court has the authority to regulate proceedings before it and to issue orders for noncompliance. The court recognized in this case that 2603 requires a preliminary affidavit. There were multiple opportunities given in the first suit, and as we've heard today, appellants have conceded that dismissal was appropriate in the first case. So then we're just left with the savings statute, and the question is whether it was discretionary under the savings statute to allow the second suit to go forward. The savings statute says that if it's dismissed for lack of prosecution, the court has the discretion to determine whether the second suit should go forward, and Jepson tells us that diligence is the hallmark of whether the second suit should be allowed in that case. In this case, the affidavit, certainly the affidavit with respect to Nurse Lorenz was still forthcoming when it was submitted days before the hearing that was set months after the motion to dismiss was filed. And again, there was no question that the dismissal of the first suit was based on the failure to produce the affidavit. So it would seem prudent that any refiling of the suit would be accompanied by the affidavits, because that was the defect that led to the dismissal of the first suit. But that didn't happen. It didn't come with a motion. It didn't come following the response. It didn't come following the reply. The month of February expired. The month of March expired. The hearing was set at the very end of April. Towards the end of April, days before the hearing, finally there was an affidavit, and again, it's a question as to whether the affidavits were even sufficient in that case, and I think that the Superior Court was correct in disregarding those. So because the savings statute afforded the trial court the discretion to determine whether the second suit should be allowed, and because there was no diligence either in the first suit or in the second suit, the Superior Court was correct to decline to allow the second suit to go forward. And unless the court has further questions, I'd like to reserve the balance of my time for my colleague.
All right, thank you, counsel. Ms. Gilbride?
Thank you, Your Honor. Eileen Gilbride for the defendants Mccarver and Prescott Valley Primary Urgent Care Clinic. I guess I would want to answer your question about whether, as a matter of law, a dismissal for 122604 would always be a lack of prosecution. And although I would love to say that it is, I think the court needs to separate out those dismissals where a plaintiff provides an affidavit, but it's substantively insufficient, from the case like this one where an affidavit is never provided.
Okay, so that's a fair point. The question would then be better stated as a matter of law when a case is dismissed under 2603 for failure to serve the affidavit.
Yeah.
Is it your position that as a matter of law, no one facing dismissal for that reason can receive automatic relief under 504?
I would agree with that because it's fundamentally incompatible with prosecution, as the court has stated many times now in this argument that is the heart of the case. It might be a mixed question of fact and law. It might be an issue of law. But certainly in this case, there's no doubt that.
Well, let me ask you about your very reasonable concession, though. If a affidavit is filed that is insufficient and the cure is insufficient to the point that dismissal results, do you believe that is a dismissal for something other than failure to prosecute?
That would be a pretty tough. That's a tough question to answer. These dismissals should happen at the very beginning of the case, and so I can see a plaintiff arguing, I haven't had time to prosecute anything. I've tried my best, and
The statutory scheme seems kind of geared to defeat an early remedy, though. The statute almost trips all over itself trying to ensure that nobody is ensnared in a gotcha, just failure to file quickly. I mean, there are all sorts of second chances,
right.
Dismissal without prejudice. I think the drafters tried not to be too harsh. So usually when you see these dismissals, it's been after, here there was a stipulated opportunity to cure, but the statute even encourages the court to grant an opportunity to cure. So
right.
It's pretty well down the road usually.
It's hard to say. I mean, I'm not a trial lawyer, so I can't say how far down the road. I think this case is highly unusual where we're almost 2 years down the road. I think, the chances that were given in this case were way beyond what happens usually. I think usually most plaintiffs try right at the outset to get their affidavit in as the rules require. But where no affidavit is filed, certainly after 2 years, I think that it can't be anything but a lack of prosecution dismissal. There's nothing that it could be. But in a different case, I would hate to see the court make some broad, ruling as a matter of law that every 2603 dismissal where there has been an attempt to file an affidavit and there's depositions and whatnot. I don't know if that would be a lack of prosecution or not.
How would that work? I mean, how would you see a dismissal where there has been an affidavit? I can imagine some sort of facial insufficiency, and then you either cure that or you don't. But it seems like if you don't cure that, I wonder how that's any different than failure to file. So long as there's an opportunity to cure.
There has to be an opportunity to cure because that's what the case that he relies on, the Sanchez case, says. You can't dismiss those with prejudice. You have to dismiss them without and give an opportunity. The question is, traditionally lack of prosecution shows in those cases the old Hosagai versus Kadada or whatever those cases are, that both the parties were doing things and depositions were occurring and there were things happening. That's what prosecution is. I suppose there could be a case where parties are arguing about the sufficiency of the affidavit over here and still doing all those things over there. I don't think that's likely.
So are you saying then that the dismissal could be based on a medical disagreement with the court. The court deems something insufficient despite amazingly diligent efforts. They just differ on what an appropriate standard of care expert needs to say.
Well, either that or the qualifications of the expert. Usually, it's whether it's this subcategory of
Well, that's 2604.
right.
Yeah, okay.
This medical expert, that medical expert. So, but I agree that those difficult, line drawing doesn't have to be done in this case because clearly it was a lack of prosecution.
Ms. Gilbride, let me just follow up on that. So are you arguing that a dismissal for lack of prosecution always involves some element of discretion by a trial judge? They have to consider the facts of the particular case rather than just the statutory basis, as here, 122603?
The normal case, the non-2603 case, yes, they would have to consider what's been done and what hasn't been done. In this case, in the 122603 realm, the legislature has told us what is required to prosecute the case. And so I think in these cases where there has been no compliance with the statute, you can say that's a lack of prosecution.
As a matter of law?
Where there has been no effort to provide the affidavit.
There's been no affidavits.
No affidavit, right, exactly. We don't know what the efforts
So you're
have
saying
been.
there's a difference between statutes and rules?
There's a difference between statutes and rules.
In other words, if you fail to comply with Rule 26.1, that requires a fact-sensitive investigation. But if you fail to comply with 122603, there's a pretty clear, bright line.
Potentially. I don't know if that makes sense to me, but when you put it like that, possibly. If the court, I was wondering if the court had any pause at all about the language of the statute and whether the fact that the dismissal did not say lack of prosecution and the 12504 requires a dismissal for lack of prosecution. The language, however, this is plaintiff's argument, that unless it says dismissal for lack of prosecution, it's not a dismissal for lack of prosecution. I don't think the court needs to pause too long about that because the statute talks about the manner of dismissal, not the reason for dismissal. So the manner of dismissal is what happened to cause this case to go away, not was the case dismissed under Rule 41, which is plaintiff's argument.
Wasn't the manner of dismissal here a motion to dismiss?
It
Which
was-
could encompass lots of reasons.
Right, exactly. And the fact that the statute talks about the manner of dismissal and not the actual lack of prosecution under Rule 41 means that the first dismissal certainly could be for lack of prosecution. Just because it didn't say lack of prosecution doesn't mean it wasn't for a lack of prosecution. It could constitute a lack of prosecution, and that's what we've been talking about.
I'm sorry, but I'm not following that. That sounds
Okay.
almost to work against you. I'm not understanding your logic.
Okay, so plaintiff is arguing, if I understand correctly, that the 12504 only applies to Rule 41 dismissals for lack of prosecution, where somebody has dismissed or somebody has moved for dismissal under Rule 41 because plaintiff has not prosecuted the case diligently, and that 122604 doesn't appear in the statute, the saving statute. Therefore, that is not a lack of prosecution type dismissal. I disagree with that because the statute talks about the manner of dismissal being for a lack of prosecution type case. So even if the case is dismissed under 38.1F, for example, that's a lack of prosecution dismissal.
Oh, well, let me ask you this. Let's say forget med mal for a moment. Just make it easy. You've got a simple contract case. The plaintiff produces no evidence, no disclosures, responds to discovery, but with immaterial items, and there's a motion for summary judgment saying plaintiff's got nothing.
Right.
Summary judgment granted. Is that a lack of prosecution? Would we then say that because summary judgment was granted because the plaintiff failed to present any evidence, that the plaintiff failed to prosecute its case?
Only technically.
Well, but we're trying to define this term under the statute. Would we say that technically the failure to produce evidence in whatever rule context, is ultimately a failure to prosecute by the plaintiff?
I don't think in the summary judgment context, where plaintiff has come up with all kinds of garbage that doesn't meet the elements of his case, that's not necessarily a failure to prosecute. That's just a substantive failure to go.
Okay, and so what if plaintiff doesn't come up with any garbage? Plaintiff just
Doesn't do anything.
serves the complaint,
Right.
takes some discovery of its own, but doesn't respond to any discovery and gets summary judgment. Is
Yeah,
that
and I
failure
think
to prosecute?
I think it could be, depending on the circumstances, and the judge would have to decide that. If the court has no other questions, we would just ask you to affirm.
No, thank you, counsel.
Thank
Mr. Berlin?
Thank you. If I may, as quickly as I can, I'd like to reply to some of the things that were said. And so with respect to Jepson and the Jepson factors, respectfully, I'm going to refer the court to plaintiff's reply brief at pages 13 to 16, including footnote 6, where the Jepson factors are laid out and discussed. With respect to what we're hearing today, if there was any magic language in Judge Mackey's dismissal, the initial dismissal, it is the phrase "outside the scope." Lack of prejudice was outside the scope of his ruling. In response to one of the questions that came from the bench, if every 122603F dismissal is for lack of prosecution, then no 2603F dismissal will qualify for the protection of the saving statute. I doubt that that's what the legislature intended.
Well, what the legislature probably intended is that these things would be resolved long before the expiration of the statute of limitations.
That, respectfully, Your Honor, is not really reasonable. Cases can be filed anywhere from the day after the statute of limitations begins to run until the day before it has run, and many cases are filed in the last days.
And that's certainly true.
The affidavits
Counsel,
that
you are out of time. Do you have something that you want to wrap up your argument with? We'll permit that, but I just want
only to point out, Your Honor, that the case, Ms. Passmore's case has merit. The reason that the affidavits of the experts were filed shortly before the hearing dismissing the second case had nothing to do with attempting to cure what was already a final determination in the first case. It was intended to show Judge Mackey, number one, that the case really does have merit, and number two, that there would be no further delays in getting affidavits, and technically those affidavits were quite early in the second case.
Thank you, counsel. We'll take this matter under advisement. We'll issue a decision in due course. Court's in recess.